we're back in the record on State versus Ivan Andrews, C346550-2. It looks like we've got the entire jury here, so we'll bring them in. Parties stipulate to the presence of the jury.
Yes, Your Honor. Yes, Your Honor.
Okay, you may be seated. Welcome back, ladies and gentlemen. At this time, I'm going to read the jury instructions to you. These are the instructions on the law that are being given to you by the court. You will get copies of them back in the jury room, so if I go too fast or something, don't worry. You will have adequate copies back in the room. So, instruction number 1. It is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law as stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law other than that given in the instructions of the court. 2. If in these instructions any rule, direction, or idea is repeated or stated in a different way, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. 3. A second amended superseding indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of guilt. In this case, it is charged in an indictment that on or about the 17th day of October 2019, within the county of Clark, state of Nevada, contrary to the form, force, and effect statutes in such cases made and provided, and against the peace and dignity of the state of Nevada, the defendant Ivan J. Andrews Jr. committed the crimes of count 1, conspiracy to commit murder, did with Michael Jerome Anderson Jr. willfully, unlawfully, and feloniously conspire with each other to commit murder by the defendants committing the acts as set forth in count 2, said acts being incorporated by this reference as though fully set forth herein. Count 2, murder with use of a deadly weapon. Did with Michael Jerome Anderson Jr. willfully, unlawfully, feloniously, and with malice aforethought, kill Corey Jones, a human being, with use of a deadly weapon, to wit, a firearm, by shooting at and into the body of the said Corey Jones, the said killing having been willful, deliberate, and premeditated, the defendants being criminally liable under one or more of the following principles of criminal liability, to wit, 1. Directly committing the crime, and or 2. By aiding or abetting in the commission of the crime with the intent that the crime be committed by counseling, encouraging, hiring, commanding, inducing, or otherwise procuring the other to commit the crime, and or 3. Pursuant to a conspiracy to commit this crime with the intent that the crime be committed, defendants aiding and abetting and or conspiring by defendants acting in concert throughout. Count 3. Discharge a firearm from or within a structure or vehicle. Did with Michael Jerome Anderson Jr. willfully, unlawfully, maliciously, and feloniously, while in, on, or under a motor vehicle located at Revere and Alexander in North Las Vegas, Clark County, Nevada, discharge a firearm within or from the motor vehicle while being within an area designated by a city or county ordinance as a populated area for the purpose of prohibiting the discharge of weapons, the defendants being criminally liable under one or more of the following principles of criminal liability, to wit, 1. By directly committing the crime, and or 2. By aiding or abetting in the commission of the crime with the intent that the crime be committed by counseling, encouraging, hiring, commanding, inducing, and or otherwise procuring the other to commit the crime, and or 3. Pursuant to a conspiracy to commit this crime with the intent that the crime be committed, defendants aiding or abetting and or conspiring by defendants acting in concert throughout. Count 4. Discharging firearm at or into occupied structure, vehicle, aircraft, or watercraft. Did with Michael Jerome Anderson Jr. then and there willfully, unlawfully, maliciously, and feloniously discharge a firearm at or into a motor vehicle, a Nissan Versa bearing Nevada license 668F86, said motor vehicle not having been abandoned, located at Revere and Alexander in North Las Vegas, Clark County, Nevada, the defendants being criminally liable under one or more of the following principles of criminal liability, to wit, 1. Directly committing the crime, and or 2. By aiding or abetting in the commission of the crime with the intent that the crime be committed by counseling, encouraging, hiring, commanding, inducing, and or otherwise procuring the other to commit the crime, and or 3. Pursuant to a conspiracy to commit this crime with the intent that the crime be committed, defendants aiding or abetting and or conspiring by defendants acting in concert throughout. Count 5. Attempt murder with use of a deadly weapon. Did with Michael Jerome Anderson Jr. willfully, unlawfully, feloniously, and with malice aforethought, attempt to kill Keandre Albert, a human being, with use of a deadly weapon, to wit, a firearm, by shooting at and into the body of the said Keandre Albert, the said killing having been willful, deliberate, and premeditated, the defendants being criminally liable under one or more of the following principles of criminal liability, to wit, 1, by directly committing the crime, and or 2, by aiding or abetting in the commission of the crime with the intent that the crime be committed by counseling, encouraging, hiring, commanding, inducing, and or otherwise procuring the other to commit the crime, and or 3, pursuant to a conspiracy to commit the crime with the intent that the crime be committed, defendants aiding or abetting and or conspiring by defendants acting in concert throughout. Count 6, attempt murder with use of a deadly weapon. Did with Michael Jerome Anderson Jr., willfully, unlawfully, feloniously, and with malice aforethought, attempt to kill Tristan Neal, a human being, with use of a deadly weapon, to wit, a firearm, by shooting at and into the body of the said Tristan Neal, the said killing having been willful, deliberate, and premeditated, the defendants being criminally liable under one or more of the following principles of criminal liability, to wit, 1, by directly committing the crime, and or 2, by aiding or abetting in the commission of this crime with the intent that the crime be committed by counseling, encouraging, hiring, commanding, inducing, and or otherwise procuring the other to commit the crime, and or 3, pursuant to a conspiracy to commit this crime with the intent that the crime be committed, defendants aiding or abetting and or conspiring by defendants acting in concert throughout. It is the duty of the jury to apply the laws contained in these instructions to the facts of the case and determine whether or not the defendant is guilty of one or more of the offenses charged. Each charge and the evidence pertaining to it should be considered separately. The fact you may find a defendant guilty or not guilty as to one of the offenses charged should not control your verdict as to any other offense charged. 4. In this case, the defendant is accused in an indictment alleging an open charge of murder with use of a deadly weapon. This charge includes and encompasses murder of the first degree and murder of the second degree. The jury must decide if the defendant is guilty of any offense, and if so, of which offense. 5. Murder is the unlawful killing of a human being with malice aforethought, either express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. 6. Malice aforethought means the intentional doing of a wrongful act without legal cause or excuse, or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed. It may also arise from any unjustifiable or unlawful motive or purpose to injure another, proceeding from a heart fatally bent on mischief, or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes an unlawful purpose and design as opposed to accident and mischance. 7. Express malice is that deliberate intention unlawfully to take away the life of a human being, which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears, or when all the circumstances of the killing show an abandoned and malignant heart. 8. Murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All 3 elements, willfulness, deliberation, and premeditation, must be proven beyond reasonable doubt before an accused can be convicted of first-degree murder. 9. Willfulness is the intent to kill. There need be no appreciable time of space between formation of the intent to kill and the act of killing. 10. Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of the action. 11. A deliberate determination may be arrived at in a short period of time, but in all cases that determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes the intent to kill. 12. Premeditation is a design, a determination to kill, distinctly formed in the mind by the time of the killing. 13. Premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. 14. The law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. 15. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder in the first degree. 16. The prosecution is not required to present direct evidence of a defendant's state of mind as it existed during the commission of a crime. The jury may infer the existence of a particular state of mind of a party or witness from the circumstances disclosed by the evidence. 17. The intention to kill may be ascertained or deduced from the facts and circumstances of the killing, such as the use of a weapon calculated to produce death, the manner of its use, and the attendant circumstances characterizing the act. 18. All murder which is not murder of the first degree is murder of the second degree. Murder of the second degree is murder with malice aforethought, but without the admixture of premeditation and deliberation. 19. If you find the state has established the defendant has committed murder of the first degree, you shall select murder of the first degree as your verdict. The crime of murder of the first degree includes the crime of murder of the second degree. You may find the defendant guilty of this lesser included offense of murder of the second degree if One, after first fully and carefully considering the charge of murder of the first degree, you either A, find defendant not guilty of that charge, or B, are unable to agree whether to acquit or convict on that charge. And two, all 12 of you are convinced beyond a reasonable doubt that the defendant is guilty of murder of the second degree. If you are convinced beyond a reasonable doubt that the killing was unlawful, but you have a reasonable doubt whether the crime is murder of the first degree or murder of the second degree, you must give the defendant the benefit of the doubt and return a verdict of murder of the second degree. 20. In arriving at a verdict in this case as to whether the defendant is guilty or not guilty, the subject of penalty or punishment is not to be discussed or considered by you and should not in any way influence your verdict. If your verdict is murder in the first degree, you will, at a later hearing, consider the subject of penalty or punishment. 21. As used in these instructions, a deadly weapon means any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death. You are instructed that a firearm is a deadly weapon. 22. The state is not required to have recovered the deadly weapon used in an alleged crime or to produce the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. 23. In order to use a deadly weapon, there need not be conduct which actually produces harm, but only conduct which produces a fear of harm or force by means or display of the deadly weapon in aiding the commission of the crime. 24. Attempt murder is the performance of an act or acts which tend but fail to kill a human being, when such acts are done with express malice, namely with the deliberate intention unlawfully to kill. Express malice is that deliberate intention unlawfully to take away the life of a human being, which is manifested by external circumstances capable of proof. It is not necessary to prove the elements of premeditation and deliberation in order to prove attempt murder. 25. The intent of a person or the knowledge of that person that a person possesses at any given time may not ordinarily be proved directly because there is no way of directly scrutinizing the workings of the human mind. In determining the issue of what a person knew or what a person intended at a particular time, you may consider any statements made or acts done by that person and all other facts and circumstances received in evidence which may aid in your determination of that person's knowledge or intent. You may infer, but you are certainly not required to infer, that a person intends the natural and probable consequences of acts knowingly done. It is entirely up to you, however, to decide what facts to find from the evidence received during this trial. 26. Any person who is in, on, or under a structure or vehicle and who maliciously or wantonly discharges or maliciously or wantonly causes to be discharged a firearm within or from the structure or vehicle, and the structure or vehicle is within an area designated by city or county ordinance as a populated area for the purpose of prohibiting the discharge of weapons, is guilty of discharging a firearm within or from a structure or vehicle. As used in the instructions, vehicle means any motor vehicle or trailer designed for use with a motor vehicle, whether or not it is self-propelled, operated on rails, or propelled by electric power obtained from overhead wires. 27. Any person who willfully and maliciously discharges a firearm at or into an occupied building, vehicle, or structure is guilty of discharging firearm at or into structure, vehicle, aircraft, or watercraft. An occupied building, vehicle, or structure is one which has not been abandoned. Vehicle means any motor vehicle or trailer designed for use with a motor vehicle, whether or not it is self-propelled, operated on rails, or propelled by electric power obtained from overhead wires. 28. A conspiracy is an agreement between two or more persons for an unlawful purpose. To be guilty of conspiracy, a defendant must intend to commit the specific crime agreed to. The crime is the agreement to do something unlawful. It does not matter whether it was successful or not. Mere knowledge or approval of, or acquiescence in, the object and purpose of a conspiracy without an agreement to cooperate in achieving such object or purpose does not make one a party to conspiracy. Conspiracy is seldom susceptible of direct proof and is usually established by inference from the conduct of the parties. In particular, a conspiracy may be supported by a coordinated series of acts in furtherance of the underlying offense sufficient to infer the existence of an agreement. 29. It is not necessary in proving a conspiracy to show a meeting of the alleged conspirators or the making of an express or formal agreement. The formation and existence of a conspiracy may be inferred from all circumstances tending to show the common intent and may be proved in the same way as any other fact may be proved, either by direct testimony of the fact or by circumstantial evidence or by both direct and circumstantial evidence. 30. Where several parties knowingly and with criminal intent join together in a common design to commit any unlawful act, each is criminally responsible for the acts of his co-conspirator committed in furtherance of the conspiracy. In contemplation of law, the act of one is the act of all. However, a defendant cannot be liable under a conspiracy theory of liability for acts committed by a co-conspirator unless the defendant also had the intent necessary for the particular crime. 31. Wherever there is slight evidence that a conspiracy existed and that the defendant was one of the members of the conspiracy, then the statements and the acts by the person likewise a member may be considered by the jury as evidence in the case as to the defendant found to have been a member, even though the statements and acts may have occurred in the absence and without the knowledge of the defendant, or even prior to the defendant joining the conspiracy, provided such statements and acts were knowingly made and done during the continuance of such conspiracy and in furtherance of some object or purpose of the conspiracy. 32. A conspiracy to commit a crime does not end upon the completion of the crime. The conspiracy continues until the co-conspirators have successfully gotten away and concealed the crime. 33. While a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of liability in arriving at your verdict. In other words, you do not need to be unanimous in deciding whether the defendant is responsible by directly committing an offense or by conspiring or aiding and abetting, so long as all of you agree the defendant is guilty of committing the crime beyond a reasonable doubt. 34. A statement offered against the defendant, which is a statement made by a co-conspirator of the defendant during the course and in furtherance of the conspiracy, may be considered by the jury. 35. Each member of a criminal conspiracy is liable for each act and bound by each declaration of every other member of the conspiracy if the act or the declaration is in furtherance of the object of the conspiracy. The act of one conspirator pursuant to or in furtherance of the common design of the conspiracy is the act of all conspirators. Every conspirator is legally responsible for an act of a co-conspirator that follows as one of the probable and natural consequences of the object of the conspiracy, even if it was not intended as part of the original plan and even if he was not present at the time of the commission of such act. 36. Once a person joins a conspiracy, that person remains a member until he withdraws from it. A person can withdraw from a conspiracy by taking some positive action which disavowed or defeated the purpose of the conspiracy. It is not enough if the evidence shows that the defendant merely ceased his own activities in furtherance of the conspiracy. The state has the burden of proving beyond a reasonable doubt that the defendant did not withdraw from the conspiracy. 37. Specific intent is the intent to accomplish the precise act which the law prohibits. General intent is the intent to do that which the law prohibits. It is not necessary for the prosecution to prove that the defendant intended the precise harm or the precise result which eventuated if a crime is a general intent crime. 38. Where two or more persons are accused of committing a crime together, their guilt may be established without proof that each personally did every act constituting the offense charged. All persons concerned in the commission of a crime who either directly or actively commit the act constituting the offense, or who knowingly and with criminal intent aid and abet in its commission, or, whether present or not, who advise and encourage its commission with the intent that the crime be committed, are regarded by the law as principals in the crime thus committed and are equally guilty thereof. A person aids and abets the commission of a crime if he knowingly and with criminal intent aids, promotes, encourages, or instigates an act by advice, or by act and advice, the commission of such crime with the intent that the crime be committed. The state is not required to prove precisely which defendant actually committed the crime and which defendant aided and abetted. 39. An accomplice is one who is subject to prosecution for the identical offense charged against the defendant on trial. To be an accomplice, the person must have aided, promoted, encouraged, or instigated by act or advice the commission of such offense with knowledge of the unlawful purpose of the person who committed the offense. A defendant cannot be found guilty based on the testimony of an accomplice unless such testimony is corroborated by other evidence which tends to connect such defendant with the commission of the crime. It is not necessary that the evidence of the corroboration be sufficient in itself to establish every element of the offense charged, or that it corroborates every fact to which the accomplice testifies. The necessary corroboration of an accomplice's testimony need not be found in a single fact or circumstance. Rather, several circumstances in combination may satisfy the law. If evidence from sources other than the testimony of the accomplice tends, on the whole, to connect the accused with the crime charged, the accomplice's testimony is lawfully corroborated. 40. To constitute the crime charge, there must exist a union or joint operation of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive is what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. 41. The defendant is presumed innocent until the contrary is proven. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged, and that the defendant is the person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt that would govern or control a person in the more weighty affairs of life. If the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, he is entitled to a verdict of not guilty. 42. The law does not compel a defendant in a criminal case to take the stand and testify, and no presumption may be raised, and no inference of any kind may be drawn from the failure of a defendant to testify. 43. You are here to determine whether the defendant is guilty or not guilty from the evidence in this case. You are not called upon to return a verdict as to whether any other person is guilty or not guilty. So if the evidence in the case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. 44. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted to or agreed by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged just as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulates to the existence of a fact, you must accept that stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. 45. Certain evidence was admitted for a limited purpose. At the time this evidence was admitted, it was explained to you it could not be considered by you for any purpose other than the limited purpose for which it was admitted. You may only consider that evidence for the limited purpose that I described and not for any other purpose. 46. In the course of this trial, you have been provided with text messages between the defendant and other individuals. You are instructed that the content of the text messages from individuals other than the defendant are not evidence, and you may not consider them for the truth or falsehood of the matter asserted in the statements. The sole purpose of these text messages is to show the effect, if any, that the statement had upon the defendant and for no other purpose. 47. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which she testified, the reasonableness of his or her statements, and the strength or weakness of his or her recollections. If you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his or her testimony which is not proved by other evidence. 48. A witness who has special knowledge, skill, experience, training, or education in a particular science, profession, or occupation is an expert witness. An expert witness may give his opinion as to any matter in which he or she is skilled. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if, in your judgment, the reasons given for it are unsound. 49. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. 50. When you retire to consider your verdict, you must select one of your number to act as foreperson who will preside over your deliberation and will be your spokesperson here in court. During your deliberation, you will have all the exhibits which were admitted into evidence, these written instructions, and forms of verdict which have been prepared for your convenience. Your verdict must be unanimous. As soon as you have agreed upon a verdict, have it signed and dated by your foreperson and return with it to this room. 51. If during your deliberation you should desire to be further informed on any point of law or hear again any portion of the testimony, you must reduce your request to writing signed by the foreperson. The officer will then return you to court where the information sought will be given to you in the presence of and after notice to the district attorney and the defendant and his counsel. Playbacks of testimony are time-consuming and not encouraged unless you deem it a necessity. Should you require a playback, you must carefully describe the testimony to be played back so the court reporter can arrange her notes. Remember, this court is not at liberty to supplement the evidence. 52. During the course of this trial and your deliberations, you are not to 1. Communicate with anyone in any way regarding this case or its merits, either by phone, text, internet, or other means. 2. Read, watch, or listen to any news or media accounts of commentary about the case. 3. Do any research such as consulting dictionaries, using the internet, or using reference materials. 4. Make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on your own. 53. Now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberation by the evidence as you understand it, and remember it to be, and by the law as given to you in these instructions, with the sole, fixed, and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. At this time, I will turn it over to the state for their closing statement. Because the state has the burden in this case, they are allowed to argue both first and last with the defendant in the middle. Ms. Flack.
Thank you, Mary. 28-year-old Corey Jones is dead today because of the actions of Ivan Andrews and Michael Anderson. Because of a few fake bills, because of a marijuana deal gone wrong, because of feelings of being slighted and disrespected, Corey Jones bled out in the back seat of a Nissan Versa and took his last breath in the pavement of a North Las Vegas Walmart parking lot. And we know that that happened because this defendant fired his beloved Glock. The bullet from that Glock traveled through the Nissan Versa that Corey Jones was sitting in the back seat of. It traveled through his arm. It transected his entire torso. It severed his aorta. thereby almost instantly killing him. And it's because of those actions, ladies and gentlemen, that we have all spent the last week together looking through evidence and listening to testimony. And it's been our job as the state of Nevada to present this evidence to you in order to prove two things. First, to prove that crimes were committed, and also, of course, that the defendant, in this case, Ivan Andrews, committed those crimes. So what kind of evidence are you to consider? You heard testimony from witnesses. You saw a number of exhibits by way of photographs and videos, and of course your common sense. All of those things, that will be the tool that you use when you go back to deliberate and analyze the facts of this case with the law that Judge Kearney just read to you. There are two different types of evidence, and the judge talked to you a little bit about this in her opening statements, but I'm going to go through it again because it's very important in this case. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime charged, such as an eyewitness. Of course we have that in this case, right, by way of Michael Anderson. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. We also have that in this case in a myriad of ways. What's important to note, ladies and gentlemen, is that the law makes absolutely no distinction between the weight to be given either direct or circumstantial evidence. And any suggestion that they are different in some ways or should be considered different by you is absolutely wrong. The judge gave you an example, and I'm going to use that one again because yesterday was kind of a reflection of that. It rained yesterday, right? We were all here in this courtroom together. When we came into the courthouse, it was maybe a little bit cloudy, but at least partly sunny. When we left, it wasn't raining, but there was water on the ground. There was water on the cars. Some people on the streets even had umbrellas. It smelled like rain. It felt like rain. When we went home last night and watched the news or got on, read the news, we saw that there were flash floods. So none of us saw that it was raining yesterday, but based upon that circumstantial evidence, that chain of facts and circumstances, we know beyond a reasonable doubt, we know beyond any doubt that it rained yesterday. And we know that purely by circumstantial evidence. The law makes no distinction between the weight to be given, either direct or circumstantial evidence. So what are the crimes that are charged in this case? Conspiracy to commit murder, murder with use of a deadly weapon, discharge of a firearm from or within a vehicle, discharging firearm at or into an occupied vehicle, attempt murder for Keandre Albert, and attempt murder for Tristan Neal. There are three different theories of criminal liability. What does that mean? It means that somebody can be found guilty in three different ways. Directly committing the crime. You are the person who directly commits a crime. You can aid and abet another person in the commission of a crime, which I'll explain, or you can be guilty by way of conspiracy, also working with one or more people and conspiring that a crime occur. What do we know here? We know that Ivan Andrews and Michael Anderson were together on October 17th of 2019. Obviously, we have two or more people. So what is a conspiracy? And again, this is just to explain to you these three different theories of liability. A conspiracy is an agreement between two or more persons for an unlawful purpose. To be guilty of conspiracy, a defendant must intend to commit or to aid in the commission of the specific crime that is agreed upon. Both of them, of course, conspired with each other, but we'll talk more about that later. Aiding and abetting. A person aids and abets the commission of a crime if he knowingly and with criminal intent aids, promotes, encourages, or instigates, or by act and advice, the commission of such crime with the intention that that crime be committed. They both aided and abetted each other in these crimes also. But specifically with Ivan Andrews, he is directly liable for each and every criminal count that is alleged in this particular case. Corey died because he was murdered. He didn't die of natural causes. He didn't die of suicide. This isn't a case of self-defense. He died because he was murdered by the defendant, Ivan Andrews. The defendant is the person who armed himself with a Glock handgun. That handgun, as we know, was loaded with hollow point ammunition. After they received those fake bills, the defendant and Michael chased the victims in that Mercedes. The defendant thought about what he was going to do, and he actually talks to Michael about what he's going to do. Do you want me to do it? He affirms that what he is going to do is shoot the 3 occupants in that Nissan Versa. He rolls the window down, makes the active decision to roll the window down of the Mercedes. He aims his Glock at his intended target. He fires his weapon 5 to 6 times with the intent to kill, and of course we know he killed Corey Jones. He is directly liable as the person with the firearm, the person who fired that weapon, and the person who actually shot that weapon. He is directly liable for each and every one of these crimes. So let's talk about, before we get to the murder, some of the lesser included charges on that document to include the discharging of a firearm from or within a structure or a vehicle. Any person who is in a vehicle and who maliciously or wantonly discharges a firearm within or from the vehicle, and the vehicle is within a populated area, is guilty of discharging a firearm within or from a vehicle. This is obvious, right? He is inside that Mercedes in the passenger seat. He fires that weapon from his vehicle. He's guilty of discharging a firearm from the vehicle. Discharging at or into, similar. Any person who willfully and maliciously discharges a firearm at or into an occupied vehicle is guilty of discharging a firearm at or into the vehicle. Are they in a populated area, ladies and gentlemen? Obviously. I mean, anybody who has been in the area of that Walmart, in the area of Alexander and Revere, this is a heavily populated area within Clark County. So what do we know? That Ivan Andrews and Michael Anderson are driving in Michael Anderson's Mercedes. They pull up onto the side of that Nissan Versa, and at that point in time, the defendant, Ivan Andrews, talks to Michael about what he's going to do. He makes the decision to shoot. He makes the decision to roll that window down, aim the firearm at the Nissan, fire from his vehicle and into another moving vehicle. We know that that bullet traveled from the back driver's side. It traveled through the trunk and into the back seat, where it severed the back seat exactly where Corey Jones was sitting. It went directly through his body, literally transected his entire torso. The bullet went into the side compartment, and it even made an indentation there in the side compartment before it dropped down and was ultimately lodged and found down in the side compartment. The defendant is guilty of both of those charges. So let's get to murder. Murder with use of a deadly weapon. Let's talk first about a deadly weapon. Obviously, we know that a gun was used in this case. You heard from the medical examiner. He died by way of gunshots, and you saw those photographs for yourself. A deadly weapon is any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death. And the law makes it real easy for you. A firearm is a deadly weapon. It's important to note that the state is not required to have recovered a firearm to establish that it was used. Why? Ivan Andrews doesn't get the benefit of killing someone with his Glock, immediately getting rid of that Glock, and then being able to say, well, you know, the state didn't find that weapon. So the law accounts for the fact that when people commit crimes, they get rid of weapons. And we do not have to have found that in order to establish that it was used. We know not only that a firearm was used, but we know that the firearm that the defendant was using, that Glock GAP, that's the one that he used to kill Corey Jones. We know that on October 13th of 2019, the defendant procured that Glock 38 45 GAP, and he was happy. He sent a text out at that time on the 13th saying, yay, Glock 38 45 GAP. He had that in his possession as of the 13th.
Okay. One of them section, you feel me? Bitch all on you and all that, what? Okay, as detailed what it is.
That video was taken 4 days before Corey Jones was murdered, and the defendant is bragging on social media that he has this weapon. And as we know through the photographs and through Additionally, we know through his social media that he steps with Glocks. That is his gun of choice. He loves that weapon. He posts about it, he sings about it, he raps about it, he brags about it. He talks about the fact that he does not step with Rugers, he steps with Glocks. He's absolutely in possession of a deadly weapon on October 17th of 2019. So murder. Murder is the unlawful killing of a human being with malice aforethought, either express or implied. Malice aforethought is the intentional doing of a wrongful act without legal cause or excuse or what the law considers adequate provocation, and that can be expressed or implied. So do we have malice aforethought here? Absolutely. The intentional doing of a wrongful act. It may arise from anger, hatred, revenge, or particular ill will, spite, grudge toward the person killed. So do we have the intentional doing of a wrongful act that arises from one of these examples? Anger, hatred, revenge, or particular ill will. Did he necessarily have hatred for Corey Jones? No. You heard Michael Anderson talk about how calm he was. He was rather nonplussed by the situation. But he was certainly had a particular ill will or spite or a grudge toward Corey Jones, Keandre Albert, and Tristan Neal for slighting them with this money, disrespecting them. It may arise from any unjustifiable or unlawful motive or purpose to injure another. Certainly we have that in this case. Certainly with the type of weapon that he used and the manner in which he used it, this malice aforethought arises from an unjustifiable or unlawful motive or purpose. Or a proceeding from a heart fatally bent on mischief, or with reckless disregard of consequence and social duty. These men are driving down an occupied street in Las Vegas, Nevada. He rolls down the window and fires a weapon 5 to 6 times in an almost fully occupied vehicle. That is malice aforethought. Reckless disregard of consequence and social duty. Murder of the first degree is murder which is perpetrated by any means that are willful, deliberate, and premeditated. So what makes a murder a first degree? You have deliberation and premeditation, willful, deliberate, and premeditated killing. So I'm going to talk about these elements. A first degree murder, intent to kill. We've talked about that. Did the defendant intend to kill Corey Jones? Did he intend to even kill Keandre Albert and Tristan Neal? Absolutely. Let's look at the type of weapon that was used. A firearm is a deadly weapon, and the manner in which it was used, he fired 5 to 6 shots at close range. He targeted them directly into this Nissan. We know, of course, that at least 2 hit, right? One hits the back tire and blows out that tire and blows off the hubcap. And one goes directly where he intended it, through the back compartment, right into the back seat, almost instantly killing this man 5 to 6 times. Each time that he fired that weapon, that is a distinct expression of his intent to kill. Additionally, let's talk about what he said. His exact words to Michael Anderson were, should we go ahead and do this? Should I do this? He knew exactly what he was doing, and he did it with intent. Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of the action, and it may be arrived at in a short period of time. And premeditation is a design, a determination to kill distinctly formed in the mind by the time of the killing. Need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. So let's talk a little bit about deliberation and premeditation. You know, you may think, based upon books you've read or movies that you've seen, just hearing the word premeditation, that this is something that has to be planned out, that people have to sit and have an actual, go up, today I'm going to commit this crime, I'm going to kill somebody. Premeditation is that intent to kill, the determination to kill, is distinctly formed in the mind at the time of the killing, and it can be as instantaneous as successive thoughts of the mind. If he decided an hour before that he was going to kill Corey Jones, that's premeditation. If he made the determination that he was going to kill Corey Jones 20 minutes before, 10 minutes before, 5 minutes before, 2 minutes before, 5 seconds before. As long as that determination to kill is formed in his mind at the time of the killing, that is premeditation, and that is what we have here. And we have that here because we know what he said, and then we know what he did. And when we talk about deliberation is kind of weighing the consequences for and against something. And it's something that we do every day. You might not even know you're doing it. When you drove here today to work, you deliberated. You came up to a stoplight. If that stoplight was yellow, you instantaneously were able to decide, should I go? Should I stop? You were instantaneously able to weigh the consequences for and against that action. And it came to you as successive as instantaneous thoughts of the mind. Should I stop or should I go? You are able to look in your rearview mirror and see if there's someone behind you and if there's danger. You're able to see if there's people that may be coming from other directions. You're able to kind of gauge how much time you have. So deliberation and premeditation, these are things that can be done as instantaneous as successive thoughts of the mind, weighing the consequences for and against the killing in this case, and making that determination to kill, and that be formed in Ivan Andrews' mind at the time of the killing. And that is exactly what we saw in this case. He took that Glock, loaded with those hollow point bullets. He made that decision when he rolled that window down that he was going to fire into that Nissan Versa, killing Corey Jones and anyone else who that bullet happened to hit. If you believe that from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows premeditation, it is a premeditated murder. This, ladies and gentlemen, is a clear-cut, first-degree premeditated murder. The defendant armed himself. He discussed what he was going to do. He pointed that loaded firearm at an occupied vehicle, and he pulled that trigger. It was willful, it was deliberate, and premeditated. We have an intent to kill murder with the added elements of deliberation and premeditation. So, was there a conspiracy to commit that murder? A conspiracy is an agreement between two or more persons for an unlawful purpose. To be guilty of conspiracy, a defendant must intend to commit or to aid in the commission of the specific crime agreed to. You heard from Michael Anderson. And we know that the two of them had this plan together, that they followed this car together, that Ivan Andrews asked him, do you want me to do it? And he said yes. This is a clear-cut conspiracy out of the mouth of one of the co-conspirators. And the crime is the agreement itself. So once the two of them make that actual agreement, and in this case, it was verbal. Many times we can look at facts and circumstances to infer. In this case, we don't even have to. In this case, that communication between the two of them is a clear conspiracy. So finally, we have an attempt murder. Attempt murder is the performance of an act or acts which tend but fail to kill a human being when such acts are done with express malice, namely with the deliberate intention unlawfully to kill. So who do we have in this particular case? Keandre, Albert, and Tristan Neal. Express malice is that deliberate intention unlawfully to take away the life of a human being, which is manifested by external circumstances capable of proof. Now, certainly in this case, the defendant attempted to kill, luckily failed in killing these two men, but he fired 5 to 6 times in an almost fully occupied vehicle. Now, you may wonder, you didn't hear from Keandre Albert and you didn't hear from Tristan Neal. Certainly doesn't mean that they were not there, and it certainly doesn't mean that they were not in the car. And it certainly doesn't mean that this man didn't have the intent to also kill them. How do we know that Keandre Albert and Tristan Neal were also there? Well, you heard a 911 call where Tristan Neal called from that car saying that their friend had got shot. You saw body cam video, and on that body cam video, you saw both Keandre Albert and Tristan Neal. They were identified by numerous law enforcement officers in this case. You saw the Walmart video where from overhead you could see their car come in, you could see both of them get out and kind of in a panic look around to see if they could find anybody to help. You saw an ample amount of evidence to suggest that both of these men were in the car, and that was even came out through Michael Anderson himself. He said that the driver of the car was an African-American male with dreadlocks, obviously consistent with Keandre Albert, and he said that the other individual was an African-American man who was bald. In comparison, I guess we can say he's bald, not exactly, but it's consistent with the way that Tristan Neal looked. So clearly these two men were in that vehicle when the defendant fired 5 to 6 times trying to kill not only Corey Jones, but these two men as well. And he is guilty of attempt murder with use of a deadly weapon for trying, but luckily failing to kill Albert and Tristan. So what crimes were committed in this case? Conspiracy to commit murder, murder with use of a deadly weapon, discharge of a firearm from or within a vehicle, discharge firearm at or into an occupied vehicle, and attempt murder for both Keandre and Albert. Now, I told you that the state must prove 2 things, that crimes were committed and that the defendant, Ivan Andrews, committed those crimes. So now we kind of get to the real part of this case, right, ladies and gentlemen, and I think that this was even the defense attorney's question in opening, and they said to you, this entire case is going to rely on one question. Was the defendant the shooter? Okay? Nobody's standing before you saying that Corey Jones wasn't murdered. You know, that a firearm wasn't discharged from that vehicle or into the vehicle. That's not the argument that's been made. That wasn't what was even suggested in the defense opening. In the defense opening, Mr. Scroggins specifically said the only question will be, was the defendant the shooter? So let's talk about that. Let's talk about all of the different ways in which we know that Ivan Andrews is the person who shot and killed Corey Jones. We have text messages. We have calls. We have call detail records. We have a 7-Eleven video. The defense will tell you it's not relevant because no one was in it. It's absolutely relevant. It's absolutely relevant as to corroboration, as to times when cars came, as to times when cars left, as to how many people we know were there. It's absolutely relevant. We have photos and videos from the defendant's phone. We have photos and videos from social media. We have firearm evidence, and we have recipient witnesses, meaning somebody like Akeisha Evans, who didn't exactly see what happens, but certainly knows what happens because Michael Anderson called her and told her. And that's all, ladies and gentlemen, before we even get to or talk about Michael Anderson. So let's talk about this case through Michael Anderson's testimony, and let's go through and corroborate each and every bit of what that man told you. Now, when you're judging Michael Anderson's credibility, you want to look at a number of things. His manner upon the stand. How did he come across to you as he sat here on this witness stand, having to testify in front of this man, be cross-examined in front of friends and family? How did he come across? His relationship to parties. His fears, his motives, his interests or feelings, his opportunity to have observed the matter to which he testified, the reasonableness of his statements, and the strengths or weaknesses of his recollection. Now, one thing is very important, because certainly Mr. Scroggins talked to you about this in opening, and he certainly will talk to you about it once I sit down, and that is that Michael Anderson made the decision to enter into a negotiation with the state. He took a plea deal, and part of that plea deal was that he would testify in this case. You are allowed to consider that, and you are allowed to consider that solely for his credibility. Okay, so that means that you can consider it to say, I don't believe Michael Anderson. I don't believe Michael Anderson because he had this agreement to testify, and so maybe he's just up here lying about everything because of that agreement to testify. That is the sole reason you are allowed to consider it, okay? And the law tells you, you are here to determine whether the defendant is guilty or not guilty from the evidence in this case, and you are not called upon to return a verdict as to whether any other person is guilty or not guilty. This is the guilt phase of the defendant Ivan Andrews' case, and that is the only person whose guilt you are here to determine today. You are also not to determine or think about sentencing, about penalty for either one of these defendants. You are not to compare and contrast. Any suggestion by the defense that that's what you should do is impermissible. The conviction shall not be had on the testimony of an accomplice unless he is corroborated by other evidence, which in itself and without the aid of the testimony of the accomplice tends to connect the defendant with the commission of the crime. So that's real wordy. What does it mean? It means that Michael Anderson can't just sit up here and tell you what happened without us having something to corroborate him. Okay? It doesn't have to be, it has to just be enough that it tends to connect the defendant with the commission of this crime. We will go through this, and you will see for yourself that Michael Anderson is independently corroborated in virtually every single sentence that came out of his mouth. What did he tell you? He testified before you, and he told you that he was going to make some runs selling marijuana. He agreed to pick Ivan up and take him somewhere, and that Ivan lived by Nellis Air Force Base, that he texted Ivan and told him that he was there. What do we know just so far? You saw call detail records that directly corroborate and independently corroborate what Michael Anderson said. You also saw text messages between Michael Anderson and Ivan Andrews that they were going to meet up. You also saw mapping that showed you that Michael Anderson's phone traveled, just as he said, to the defendant's home. He said that Ivan got into his car and he showed Michael a big Glock handgun, and he said, "Look at my new baby." You saw videos and you saw photographs. This man loved this weapon. He loved this weapon. That statement, "Look at my new baby," is directly corroborated by Ivan Andrews' own words in his text messages in his phone, in his videos in social media, in his posts in social media. And we know that he did have a big Glock, and it was new, that on the 13th of October of 2017, he got that Glock when he said, "Yeah, I just got my new Glock." He was happy about it, and it was, as he said, new. You saw that text message through his timeline, and again, his social media posts bragging about the fact that he loves Glocks. He steps with Glocks. That is his gun of choice. Michael Anderson testified, and he told you that he had his mom's purple 9mm Ruger, that he never had a .45 because a .45 was too big for him, and that his mom never had a .45. What independent corroboration do we have? Well, how about Ivan Andrews himself? Ivan Andrews told you that on October 17th that Michael Anderson had a purple Ruger. When the police went and they did a search at Michael Anderson's mother's home, what did they find? A purple Ruger. What didn't they find? Never found a .45. You also heard from Michael's mother, and she told you she's never had a .45. Direct corroboration of Michael Anderson. Michael told you that he was contacted by Corey Jones and that they decided to meet up at the 7-Eleven. And sure enough, at 1:16 p.m. on the 17th, the text between the two of them, and Michael said to him that he would be waiting or asking, "Can we meet at the 7-Eleven at Revere and Craig?" Direct corroboration. Michael testified and told you that he was driving his Mercedes-Benz. Of course, we know that when he was apprehended, his car was found at that Walmart, and it's that silver Mercedes-Benz that he testified he drove. That Ivan was with him the whole time. We know that for a fact, beyond a reasonable doubt, beyond any doubt, through the circumstantial evidence of all this case. He said he never had an issue with Corey. He was waiting at pump 8, that the Nissan Versa pulled up. Corey hopped out of the back seat, that the driver had dreads, the passenger was bald, and everyone was African American. What independent corroboration do we have? Well, we know he was waiting at pump 8, and we'll see that 7-Eleven video in a moment. We know exactly as he said, that the Nissan Versa pulled up while he was waiting. The Mercedes is there first, then Nissan pulls in second. We know from that movie, or that video that we will watch, that Corey hops out of the back seat. And what else do we know that is independent corroboration of Michael Anderson? That the driver was Keandre Albert, an African-American male with dreads, and that the passenger was Tristan Neal, an African-American male that's somewhat bald. At 2:19, Michael Anderson sends a text message to Corey Jones saying, "I'm at pump 8. Direct corroboration of Michael Anderson. here we can see, ladies and gentlemen, in this video from 7-Eleven, that at pump 8, that Nissan is at pump 8, and now Corey Jones has pulled up in the Mercedes. That the Mercedes is at pump 8, and that Nissan Versa is pulled up. That Corey Jones walks from the Nissan Versa over to the driver's side. If you want to watch this when you are back during your deliberations, you can actually see Corey Jones through the gap in those pumps. He is standing outside the entire time, moving and talking clearly to Michael Anderson, who is in the front seat. He now goes back to his, to the Nissan. And the Nissan leaves the 7-Eleven. At this point, you distinctly see the passenger side door right there open up on that Mercedes. It opens and closes, and they take off. There's a second individual in that car, as we know, and that person is Ivan Andrews. Michael testified that Corey walked to his window and an exchange happened. What do we know from the search of the car? Independent corroboration by way of a bag of marijuana. He said that the Nissan, quote, smashed off, that it went off super fast. And you kind of saw that in the video, right? It did kind of take off fast. And that Ivan let him know at that point in time that the money was fake. And he was surprised that Corey gave him fake money. He looked at it and he realized also that it was fake. He felt upset, he felt disrespected, and so he followed that car. Independent corroboration of Michael Anderson came by way of crime scene analysts. Now, some suggestion that he's making this up, some suggestion that he testified the way that he did from the witness stand in order to get this deal from the state. How in the world would Michael Anderson know that crime scene analysts were going to use a special pen over those $20 bills to determine that that money is fake? Because crime scene analysts determined that that money was fake. So the boys looked at it and they thought so, and crime scene analysts, independent of Michael Anderson, came to the same conclusion. How in the world would Michael Anderson have known that? Michael Anderson testified that he called and he texted Corey, that he called Keisha and that he was very upset, and he told her that Corey paid him with fake money, and he texted Corey, bitch ass. Who did you hear from? You heard from Keisha, and she told you that she was at work at Jack in the Box, and she first got a call from Michael Anderson, and he was upset. He had felt disrespected. And she said, okay, I'm gonna try to call him and figure out what's going on. Keisha Evans was direct, and I may have said Keisha Anderson, I'm sorry if I did. Keisha Evans is direct corroboration as to what Michael Anderson told you. We also know that, just as Michael Anderson said, at 2:54 p.m., he sent that text that he testified to you, that he sent, and called Corey Jones a bitch ass. And that was just 24 minutes after the shooting. Of course, at this point in time, they still don't know whether or not, and have not confirmed, that Corey Jones has been hit. Michael Anderson testified that they caught up to the Nissan, that Ivan asked, you want me to do that? You want me to do that to him? And he said yes, because he was so upset. That Ivan pulled out the gun, started shooting, and he shot 5 to 6 times. He testified that a hubcap even popped off the car. What do we know about that Nissan Versa? Independent corroboration of Michael Anderson's testimony. That back tire on the driver's side is popped out, it's blown out. And what's missing? What flew off? Just as Michael Anderson said, the hubcap. Additionally, we know that 5 to 6 shots were fired, one of which went through that tire, one of which of course goes through the back seat of the car. Direct, independent corroboration of Michael Anderson's testimony. What do we know about that bullet that was found over in the side panel of the driver's side, of the passenger side back seat? So you heard from Roy Wilcox, and this is extremely important and extremely interesting. We know that that firearm bullet was a hollow point bullet. Roy told you about that bullet, and he told you that what is distinct and unique about this particular bullet fired and it gets into liquid, as he described it. It's almost to blossom and spread out. And that's exactly what this is. It's a very distinct type of a bullet, a hollow point. But who uses them? The defendant. Who has a magazine, who has photographs of himself with that magazine in his phone, bragging to people, talking about, you know, his ammunition and his guns? The defendant. And you can see in these photographs at the end of that magazine that clear and distinct hollow point bullet. What else do we know about the bullet that was examined? There were 3 different firearms that were given to Roy Wilcox. 2 of them, of course, came from Michael Anderson's mother's home. When that was tested, that was not the weapon. 1, also not a Glock, was found with the defendant when he was arrested, and that was not the murder weapon in this case. None of those 3 weapons, either the ones that came from Michael Anderson's mom's home, or the one that was found with the defendant at the time of his arrest, none of those fired that bullet. But what do we know about the bullet? That it was consistent with a nominal .45 caliber to include .45 auto and .45 GAP, with general rifling characteristics similar to include Versa and Glock pistols. Mr. Ogata, during his cross-examination, kind of talked about, oh, well, there's tons of Glocks out there, sure, agreed. And there's Versas, and even besides a Glock and a Versa, there's still other firearms that could have fired this bullet, and that's true, but that's not the question. The question is, would a .45 GAP pistol be capable of firing that particular bullet? Would the firearm that we know was in the hands of Ivan Andrews in that passenger seat on October 17th, would that particular pistol be capable of firing this particular bullet? And the answer is a resounding yes. So we are not concerned, ladies and gentlemen, with all of the guns that could potentially fire this bullet. We are only concerned with whether or not the gun that was in defendant's hand on October 17th as he sat in that passenger seat is capable of firing that bullet. The answer is yes. Michael Anderson testified that he busted a U-turn, that he was super scared. He called Keisha and he told her at that point we shot up the car, and that he didn't know if anyone got hit. And what do we know from the defendant's own text messages after the shooting? That he says at 3:38, when he's trying to sell the Glock, which we'll go through, but he specifically says, let me know, bro, because I'm accepting trades. At this point, I don't know if cut, hit, or not. C-U-H. You determine whether or not that means I don't know if cousin got hit. Obviously, this is an hour after the murder. He's trying to sell the weapon. He doesn't know if Corey Jones, who's Michael Anderson's cousin, got hit or not. And that is consistent with Michael Anderson, and it's direct corroboration of what Michael Anderson told you, which is that they did not know at that point in time if they had hit somebody. He testified that he was no longer angry, but now he was just scared, and that there were multiple phone calls from Keisha. And he specifically said to Mr. Hamner's question, he was ghosting her. He was just pretending like he didn't exist. He was not answering any of her calls. You heard from her, and she told you that she was trying desperately to reach him at that point in time, also trying to reach her husband. He said that he called his mother. We know that he did try to call his mom. You heard from his mom, and she said that he called her, that he was upset, that he was frantic, and that he didn't tell who he shot or who exactly was the shooter, but that he said something to her about someone being shot, and it caused her to go to where he was. We also know that many of these phone calls were placed because you saw the actual call log, where Keisha is calling Michael Anderson over and over and over and over again, and it's unanswered until she finally tells him Corey's been shot. So she texted and she said that Corey had been shot. He testified to you about this, and he told you that when he got the text that said that Corey had been shot, he literally felt his soul leave his body. He knew that his actions had caused his cousin to be hurt. And we saw the call log from Keisha and from Mike's phone, where Keisha texts and says, He testified that he got to his house and no one was home, and that he let Ivan know that Corey was shot, and Ivan had no reaction. And that's consistent too, right, with all of the text messages that you see in this phone. You don't see text messages of Ivan Andrews saying, my God, what have we done? Oh my God, I hope this guy's okay. What do you see text messages of him doing? Basically covering his own butt, trying to get rid of that firearm as soon as possible after he's murdered a man. Michael Anderson told us that Ivan was cleaning the shelves from the car. He flushed them down the toilet, that he was wiping down the car, and that he was wearing a gray hoodie, and that it was up during the shooting. That he burned the hoodie in the backyard, and that he was cleaning bullets in the sink with bleach. Well, what do we know about the text messages from Ivan Andrews' phone? At approximately 11:38 p.m. on the 17th, and actually we need to UTC that, so it's going to be 7 hours earlier, the defendant sends a text message to a phone number that was never identified and said, I left my bullets in the sink. He says, if you go back, get them for me, I need them. And tell Mike, call me, give me some intel. Law enforcement was never able to determine who exactly these text messages were to. But what do we know about Ivan Andrews, about how Ivan Andrews would oftentimes contact Michael Anderson? What did you learn out of his statement? What did he say? He said if he can't get in touch with Michael Anderson, who does he get in touch with? Jada. And who lived with Jada at that time? And who was at the house at some points during the day when Michael Anderson was there and when Ivan was there? Jada. Text message, I left my bullets in the sink. Entirely consistent with what Michael Anderson told you, which is Ivan Andrews, was cleaning bullets and washing those bullets in the sink. Ivan Andrews then sends a text message that afternoon that he left his bullets in the sink. Certainly, the unidentified number goes to Jada. He also then says he needs to get them back. He needs those. And then what does he say? Tell Mike to give me some intel. Who would have access to intel from Mike? And who would have access to Mike? The defendant is reaching out to Jada, telling her to get those bullets, he needs them back, and he needs intel from Mike to know whether or not Corey Jones has been shot, what people know, and what's going on. Now, Michael Anderson testified that Jada and Morgan came home super happy because they'd gotten that job at Sephora. He took Jada upstairs and he told her what happened, and he never took Ivan to his girlfriend's house. We will discuss that. Ivan was making phone calls on speakerphone, and that there was a male on the other end of the phone. He didn't recognize the voice. Of course, we know through the investigation that the male on the other end of the phone is DeAndre Taylor. Ivan was explaining what happened and talking about getting rid of the gun. We know that the defendant shot Corey Jones at approximately 2:30 p.m. and that he had 4 phone calls with DeAndre Taylor. And we know this from the records, right? He had 4 phone calls from DeAndre Taylor while he was there at Michael Anderson's house. Between 2:53 p.m. and 3:29 p.m., he had those 4 calls. And Michael Anderson told you he overheard the 2 of them talking about getting rid of a gun. And what's the very next thing that happens just 7 minutes later at 3:36? The defendant starts texting his good friend, Swabby JP, to ensure the sale of this Glock. This is direct corroboration, ladies and gentlemen, of Michael Anderson. Not to mention, and not to get into, the consciousness of guilt of this particular defendant, knowing that he just killed a man and he needs to get rid of that hot weapon immediately. That weapon now has a body on it and he needs to get rid of it. So the text messages to Suave E start earlier in the morning, but he is sending multiple photographs of this gun that you all saw from every single angle, each side, down the barrel. He's doing it in different light, he's doing it in different angles. He's sending those before the homicide happens. But immediately after, at 3:36, let's do the 5, I just got into some shit. into that would have made him need to sell the one thing we know he absolutely loves this quickly. An hour after he kills a man, he is getting rid of this weapon. Suave JB says, I'm trying up at Fu, I can only take 100, 150 was solid on me. What does the defendant say to that? Let me know, bro, because I'm accepting trades at this point. I don't know if cousin was hit or not. He and Suave JB then go back and forth to discuss the amount, possibly meeting somebody, and for a certain amount of money. You don't have to have it written out to you in these text messages, I am selling the Glock that I just murdered somebody with, to know that that's exactly what these two men are talking about. The defendant acknowledges that that Suave JB is going to meet someone on his behalf to get rid of that gun. And later that evening, at 7:38 p.m., Suave JB tells him exactly that the gun was sold. And what does he respond to that? Okay, he acknowledges and he accepts that that happened, that gun sale happened. And what's important about him saying okay, what happens after with regard to the gun? All discussions about it stop. No more pictures are sent to anybody. There's no more discussion about money. There's no more back and forth about meeting up with someone and upping it to 500 or 100 or anything. Once he gets word from Suave JB that that gun has been sold, all references to the gun stop. Why? Because it's gone. Because he sold it and he doesn't have to discuss it anymore. And that's why that exchange is so important.
Yeah, we gotta go, good. Yeah, that's the one I found. What? I'm not selling no block, bro. I didn't want to sell the one. I didn't want to sell the one that we came up with last time. Sell.
I'm not selling no block. I didn't even want to sell the one that I had to sell last time. He sold the murder weapon, and that's why you don't have it here. That's why we weren't able to produce it. That's why Roy Wilcox wasn't able to do an analysis with the actual murder weapon, because Ivan Andrews sold it. We also know from Roy Wilcox that the defendant had a Glock with a single guide before the murder weapon and a double guide after. And you can see the clear distinction in the photographs before and after the homicide that this is not the same gun. Why? Because he sold it. Michael Anderson testified, and he told you that Ivan eventually left out the backyard, that Michael went to his mom's house, that he left Vegas to Arizona that same day. He figured everything would lead back to him. He wiped his phone, and he blocked Ivan's number. What is direct, independent corroboration of Michael Anderson? Police officers did a comparison with Corey Jones's number and Corey Jones's phone and Michael Anderson's phone. Sure enough, Michael Anderson's phone was wiped. We saw evidence of calls and messages in Corey Jones's phone that was not in Michael Anderson's, because sure enough, he wiped it. Independent corroboration. When you are judging Michael Anderson's credibility, when you are assessing it with regard to the fact that he took a negotiation and he chose to take a deal in this particular case, ask yourselves how on earth he would know that all of the things that he said would be independently corroborated through text messages, calls, call detail records, through firearms analysis. How in the world would he know that? Let's talk about call detail records. We know that Michael Anderson's phone traveled to the defendant's home, that both phones, meaning Michael's and Ivan's, traveled back up to Anderson's home together before the murder, and they're both pinging there. That both phones stayed there before and after the murder, and that after the murder, after the morning, when we know that Ivan was at his girlfriend's, there's absolutely no phone activity at defendant's girlfriend's home for either of these guys. Neither of them were there. Now, the defense will certainly get up and say, well, his phone is not pinging while it was at the 7-Eleven. So he wasn't there because it wasn't pinging. It wasn't pinging, so what do we know? All that we know is that that means that there is no phone activity on Ivan Andrews' phone while he's there at the 7-Eleven. That's all that that means. In order for there to have been a ping, in order for there to have been some kind of activity that we can record, there had to literally be phone activity. So while he was with Michael Anderson is using his phone, he's not using his phone. What was he using during that time? His firearm. You will have this in evidence, but this is a map showing the movement of these phones. The blue is Ivan Andrews, and the green is Michael Anderson. You will see direct corroboration for Michael Anderson as to where he was when he went to Ivan's residence to pick him up, and then both of them go back up to Michael Anderson's residence together. You then see, of course, activity of Michael Anderson's phone going down to the 7-Eleven. And then just minutes later, they are both hitting back up at Michael Anderson's home. Why is that important? Because Ivan Andrews is using his phone. He's just not at his girlfriend's. It's not that there was no activity, and it's not that he told the police, I just kicked it up at Michael Anderson's house while he went to do the drug deal. If he had said that, might be a different analysis. But that's not what he said. What he said is, I was at my girlfriend's. He also said he was at his house. We know those are two different places. But when you're not telling the truth, sometimes you can tend to be inconsistent. But what we know is, he was absolutely not at his girlfriend's house, that his phone is pinging after the murder, a flurry of activity. Both of them, right? And just as Michael Anderson testified, both of them, a flurry of activity after the murder up at Michael Anderson's residence, and never a ping at Ivan Anderson's girlfriend, Ivan Andrews. Not only for Ivan Andrews, but also for Michael. Michael never pings down there. If he drove Ivan down to his girlfriend's home, certainly his phone would have pinged. Certainly with all the activity on his phone that day, there would have been some activity. So let's talk about Ivan's actions after the murder to show clear consciousness of guilt. What did he do? He cleaned the car. He flushed the cartridge cases. He burned his hoodie. He washed the bullets. He sold the Glock. And as of October 18th of 2019 at 2:47, he started looking up this on the news. An article talking about this particular murder. Why was he interested in this particular murder? And think about what he said in his interview with the police. He said he didn't even know about this until Michael Anderson got arrested. Well, Michael Anderson wasn't arrested until November 7th. He is searching for the exact murder that he is involved in, that he tries to claim he knew nothing about 1 day after this. Clear consciousness of guilt. There's also a whole slew of text messages that you saw between he and DeAndre Taylor analyzing this and analyzing what is said in it and what is not said in it and trying to determine what police know and if it's a setup. They have a whole conversation about putting money on giving money to Michael Anderson's mother so that she can put money on his books. Clear consciousness of guilt. What else does he do after the murder? He deletes his social media. And we know that. We know that there are the text messages, and then he goes on to do that, and he changes his number. He gets a text message from DeAndre Taylor on the 10th at 9:05 p.m. Brother, delete your Instagram app. He says, Facebook, you mean? No, really, I mean both. Really both, but mainly Insta. Why Insta? Because you posted that shit on your story, and you know Insta archives. What does he say to that? I deleted it. And what are the actions that he took after he said that? What effect did that all have on Ivan Andrews? He literally went through and deleted it, and you see that in the extraction report. He visits his social media accounts and he deletes. He deletes data that he knows will be linked back to him and this murder. And And finally, what else did the defendant do after this murder? He had an interview with the police, and he chose time and time again to deceive. He claimed he only knew of Michael Anderson from school. We know that is absolutely not true. He was internally inconsistent with that claim. He said, I only know him from school, but then within minutes of that interview, it is clear that he was with him just a month before, that they were at his home just a month before, that he contacts him often, that he contacts him through his girlfriend. These two people are friends. They know each other, and they know each other well. That was the first time that he tried to deceive the police. He literally tells the police he has no guns. I mean, this is a joke, right? This is a joke. We know from his social media, again, he loves that weapon. He loves that Glock, and every chance he has to make a video of himself, to talk about himself with it, to show people that he has it, to brag about it, every chance he has, he does. That was a straight up, flat out lie to the police. He says he went to his house, which is his granny's house, and then he would sort of morph right in between that and say, well, I also went to my girlfriend Melanie Ross's house. He sort of started to use them interchangeably. We know that those are two different homes. But that's a hallmark of when a person isn't telling the truth, because the truth is consistent. And more than anything, how do we know that he's not at Melanie Ross's? Let's just pretend he's at Melanie Ross's and that the phone isn't pinging there, because like we said with the 7-Eleven, there's just no activity. But how do we absolutely know, without a doubt, that he's not there? Because he texts his girlfriend, baby girl, who's in his phone as baby girl, and he testified, or he, in his statement, he said as such. He texts her on the 17th at 3:19 in the afternoon, babe. An hour goes by and he doesn't hear from her. And so then what does he say when he's supposed to be literally with her at her home at 4:21 p.m.? He says, hit me up when you can. That is not something that you send to somebody if you are sitting in the same home as them. He gave a fake alibi to the police. Why? Because he is guilty of a first-degree premeditated and deliberate murder of Corey Jones. And finally, the biggest of them all. He claimed that he was not with Michael Anderson at the time of the shooting and that he did not kill Corey Jones. Ladies and gentlemen, you sat through this entire trial. You heard all of the testimony in this case, and you saw all of the evidence in this case. That claim is belied by each and every witness that was on the stand and each piece of testimony and evidence that was presented to you. And because of that, ladies and gentlemen, Mr. Hamner and I, on behalf of the state of Nevada, would ask that you return verdicts of guilty for each and every count to include first-degree murder of use of a deadly weapon for the premeditated and deliberate killing of Corey Jones.
Thank you, Ms. Fleck. Mr. Scroggins, your argument.
Good afternoon, ladies and gentlemen. I want to thank all of you for your patience through this process. I know it's been a long couple of week and a half for you, I guess. And I hope that you're still alert enough to listen to what I have to say. Now, before I even start, I want to say, just so you're aware, and the judge has already said this, but when I'm finished speaking, the state gets another opportunity to speak. That's just the way that the courts are structured. Because it's their duty to prove everything beyond a reasonable doubt, they're allowed to get the last say. And I wanted to get that out there right away because I'm hoping that you'll bear with me if it takes me a little bit of time to get through this, because it's my only opportunity to address everything the state has already said and everything they're probably going to say when I get done. So I just like to get that out there at the very beginning of this stuff. Now, you guys figured out early on I'm not much of a technology guy. So I actually was going to try to be progressive, and I had somebody prepare a PowerPoint thing for me so I could show you guys with the clicker, and literally at the last minute I got cold feet. And so I'm going to still be doing it the old-fashioned way. I'm going to discuss the case with you guys, and I will put items on the overhead when I need to reference them. So one of these days, maybe I'll figure that out. Now, there is a lot to sort through in this case. The state has presented a lot of people. They've presented a lot of documents. They've presented a lot of reports to you guys. And it's really easy to forget the most basic function of a trial when you're sorting through all that stuff. And the most basic function of a trial in this country is to make sure that if we're going to convict a person of a crime, we are absolutely convinced beyond a reasonable doubt that that person is guilty. That is the structure of our system. That is why you guys today and you guys throughout these proceedings are the most important part of this process. This is July, and at the beginning of this month we had the 4th of July. It's our Independence Day. That's when we celebrate we have this country. That's when we celebrate that we live in a country that has rights, that we live in a country that will not convict a person of a crime because people think he did something or think she did something, or that they acted in ways that were consistent with somebody who committed a crime. We fought a revolution, and that was one of the primary things that we were fighting for. You see, if you live in a different kind of system, and they're all over the world, our system is based a lot on the English system because we were English colonies when this first started here, right? When we first started this experiment of the United States of America, we were colonies of the English Empire. We fought a revolution because the government of that empire could arrest you and not tell you what you were charged for if they decided that you were the type of person who may or act consistent with someone who might have committed a crime. And the people who fought our revolution said that's not justice. If you're going to charge a person with a crime, you have to tell them what you're charging them with. And not only that, you have to prove it beyond a reasonable doubt. And not only that, you have to prove it to average citizens of the country, not just a judge, not just a general at that time. A general could call you in and convict you of a crime. We have a system that is based on the idea that, hey, if someone is guilty of a crime, we're going to punish them. We have laws. And the state's gone through those. We'll talk about those, the various instructions that you'll be given about the actual crimes being charged. But we are going to make sure as we possibly can, that the state has proven everything they need to prove in a case beyond a reasonable doubt. You'll recall early on a lot of questions were asked about prejudices and things. You guys remember jury selection. We were asking you questions. We were trying to find out if you were the type of people that would keep an open mind, that would follow the law, that would follow the instructions that the judge gave you or will give you or just did, and not make a decision based on anything improper under our system, that you would not make a decision until you had seen all the evidence and you've heard the different sides' interpretation of that evidence, and you deliberated together to examine each piece of that evidence. Because he seems guilty, is not what we have. We have guilty beyond a reasonable doubt. And the importance of what you guys have to do here, John Adams was one of the founders of this country. He's one of our founding fathers. Very famous guy. And again, it was the 4th of July, this month. And so people start thinking about the founding of this country, and they start thinking about the reasons that we have a system like we do and what we fought and died for. If you remember from history, there was what they called the Boston Massacre before the Revolutionary War. It was actually considered one of the things that started the Revolutionary War. As I said earlier, the colonists, later on to be Americans, were unhappy with the government that didn't give them the kind of rights that we get here. And they were willing to fight for it. There was an incident in Boston where a rowdy crowd of colonists threatened a group of British soldiers. And the British soldiers panicked and shot some folks in that crowd. Immediately, the propaganda machine of the day jumped into full gear. And they started saying in the newspapers, and they started saying around town in the taverns and the churches, that those citizens were unarmed and that they were gunned down in cold blood by the British soldiers. Hence the name, the Boston Massacre, right? What did we do in this country, even before we had become our own country, even when we were in the midst of starting a revolution? John Adams, one of the men who fought the hardest for that revolution, one of the men who fought hard to create our system of government, was an attorney before he was a founding father. And he represented those British soldiers. He, one of the people saying we have to fight a revolution, believed so much in the rule of law that he defended the British soldiers against the very colonists that he was helping start a revolution. Now, that's kind of mind-blowing to me. But what he said, he says, the part I took in defense of Captain Preston and the soldiers procured me anxiety. But then he said, it was one of the most gallant, generous, manly, and disinterested action of my whole life. And one of the best pieces of service I ever gave to my country. You guys are the ones who make the decision here. And you've been shown a lot of things through the course of this trial that could prejudice you against Ivan. You've seen pictures, you've seen things that make him look like a bad guy. You know from the testimony of who they got that the people he hung around with and knew were pretty bad guys, right? They're selling pot, they're paying for it with counterfeit money. So they show you things and they want you to think, oh, well, he's the type of guy that would do something like this. And they want you to think that that's enough. But it's not. But it's not. At the beginning of this, you guys all made a promise to Ivan and to the state and to the judge and to me that you would listen to the evidence and you would keep an open mind and you would make your decision based on what could be proven to you. Now, the state made some promises also in opening statements, and they've been referred to, some of the things that happened in opening statements. And I made some promises. And when I was making those promises to you, I told you that what we were saying in those opening statements were not evidence, right? That's argument. That applies to me as well as the state. And I think I tried to be pretty clear on that with you guys. But let's look at the promises the state made you, because then we're going to compare those promises to what the evidence actually showed us in this trial. Number one, they told you that they were going to prove to you that the firearm that fired that fatal bullet was a Glock. Not true. I'll get to that as we get to Wilcox's testimony. Could have been, but they didn't prove it. And then they say to you, well, yeah, but this is the only gun that we think was the weapon, and so it doesn't matter if it could have been other weapons. That's the opposite of what our standard of reasonable doubt is, guys. Just as they said that they were going to prove that the gun he possessed was the murder weapon. Well, we all know they don't have a murder weapon in this case. They say that the Glock that is in the pictures with Ivan is consistent with a firearm that could have fired that bullet that could have been a .45 GAP bullet. There you go. He must be guilty. It's consistent with something that could have been maybe the thing that did it. And we think he's guilty, so everything else we would do would be stupid. I'm speaking rhetorically. Because we already know. See, the police don't take the oath that you guys do. The police are trying to build cases. The police are trying to arrest people. The police don't make a promise that they're going to be honest. They don't make a promise that they're going to examine the evidence before they act on something. And you've seen throughout this case what the police do in their investigations. They have a theory, they go try to get it. They said that they were going to prove to you that Ivan was with Michael Anderson during the commission of the crime. If you believe Michael Anderson. Now that we've seen all the evidence, we've seen everything that they've got that's going to tell us that he was with him. One person in this entire trial said that Ivan was with Anderson at the time of the crime, and that was Michael Anderson. Right? And we're going to talk about the credibility thing that she went through. She explained to you all these things that Ivan did that are consistent with lying to the police. But we shouldn't consider that for Andrews, right? Because Andrews, he's lying. He's lying. But Anderson, well, he's not. Even though everything they said about Ivan applies more so to Michael Anderson. But yet you should believe him. They said that they were going to prove to you that Ivan was the one who shot the car. Once again, not a single witness says that except Michael Anderson. There's two victims in this case that didn't testify, and they're being called victims of attempted murder. They never said Ivan was involved in this. No one ever said they saw Ivan, and how do we know that? Well, they didn't come in here to testify. But we know that because when my colleague, Mr. Ogata, was cross-examining the police officers yesterday, the detective and the sergeant, he asked them, you don't have any other witnesses that said that Ivan was there, do you? And he said, no. No. We've got Michael Anderson. Then they told you that Ivan must be guilty because he tried to sell the gun after the shooting happened. Right? That proves that he's guilty. That proves that that was the murder weapon. But what do? Once again, they gloss over the fact that the same type of evidence that they're using to establish that to you guys shows, according to them and their interpretation, that he was trying to sell that gun on the 13th. Right? But that doesn't matter. That part doesn't matter. Because that doesn't show consciousness of guilt. That just shows a guy who was trying to sell a gun before his friend killed somebody and then after his friend killed somebody. Once again, where's the proof? Once again, what does it prove if someone says something or tries to do something and then something happens involving their friend and they keep trying to do the same thing? But it's consistent with a person trying to get rid of a murder weapon. So he must be guilty. This case would be real easy if we could do that, but it wouldn't have taken this long and I wouldn't be talking to you. And then the last thing they promised you was that they would prove to you that Ivan was not at his girlfriend's house. They kept that one. He wasn't there. The evidence shows he wasn't at his girlfriend's house when he told the police he was. So he lied. He lied over a month after the incident when he was called in for police questioning, knowing that his buddy, who he admits he hung around with, had been charged with murder. And so what does he do? He lies. He says, they say, where were you a month and a couple weeks ago when this happened? And I was with my girlfriend all day. Right? They say, do you have guns? He says, no, I ain't got no guns, right? But that's the extent of his lying. Because unlike Anderson, Ivan wasn't going to admit doing something he didn't do. And he never did. He never did. And he's on trial today. And that's why we're here. And that's why you're here. Now, I told you I made some promises as well. I told you that the evidence was going to show you certain things. And I asked you to look at the evidence instead of what I was trying to tell you it meant, right? Some of you might recall. One of the things I promised you was that the ballistics evidence in this case would not prove that that fatal bullet was fired by a Glock at all, let alone the firearm that's shown with Ivan in the pictures. And what did we have? We had the state's ballistics expert, Mr. Wilcox, came in here, and he told you guys, after some cross-examination, that just as I said in the opening statement, that the evidence showed that it could have been a 45 auto or a 45 gap. He does not know which one. That's the best he can do. He told you guys, as I said would happen, that there are literally thousands of firearms around this country or in this city that could have fired that bullet. They told you during the opening that they would prove it was a Glock, and the evidence doesn't prove it was a Glock because on cross-examination he admitted that there's a lot of different types of firearms that fire 45 calibers of auto or GAP. Just as I told you was going to be shown through the evidence. They said that they tried to say that the way that the grooving was on the bullet also proved it was a Glock, but once again, it doesn't. You heard the evidence. You heard the actual evidence. One more promise that I kept. I told you that they would show you by their, or that the evidence would show, not what they would show, that the evidence would show that there's nothing showing that Ivan was at that crime scene on that day at all. If you remember, I had one exhibit on, and it's not an exhibit because it's not evidence, but on opening statement I showed you the map. And I told you, when you're examining evidence, if you can't decide who's telling the truth and who's not, look at the scientific evidence that's been produced. Then you don't have to worry about that, because we're going to get into having to do that in a minute. But once again, they say that the absence of any cell phone activity at the girlfriend's proves he wasn't there, but the absence of any of his cell phone activity at the crime scene doesn't mean anything because we know he did it. So he must have had his phone off, or there must have been something weird going on at that period of time. Once again, it's the opposite of the standard we have in this country. They don't get to say it's consistent with someone who turned their phone off. Come on. And we'll talk about some of the data that was not provided, that only came out when their witness was testifying, showing that what they were provided by the state or the police was not the complete data, because they had data that looked like there was no cell phone activity for at least an hour period around the time of that crime. But they didn't give the person the data that shows that the phone is active and on, the step data. They didn't give them that, right? She testified, and we'll get to her, that all she could testify about was what she was given. And she was pretty clear and frank about the fact that she wasn't given everything. So, it proves that he's not, the cell phone stuff proves he's not at his girlfriend's, but it doesn't mean anything when it shows he's not at the crime scene. That's what they're trying to get you to believe. Can't have it both ways. I also told you in opening that they were going to show you a bunch of videos and pictures and things of Ivan looking like a thug, right? Singing to rap music, showing guns and acting tough. And I told you that that's not evidence that he committed this murder. That's evidence that he is, I think I said stupid. I apologize if that's the word I used. But I think I said it shows he's a stupid young man trying to show out about how bad and tough he is, right? Again, it's consistent with somebody who might be a murderer, right? But it's not proof. It's not proof. We're not allowed to decide things based on prejudice, and I asked you all specifically, is it going to prejudice you that he's a young black man with tattoos and into some stupid cultural stuff? And every one of you said no. I don't know if you're able to do that. I hope you are, but every one of you said you would not do that, that you can be fair, that you wouldn't judge him by what he looks like or how he acts. Then, I promised you that the state's witnesses who told you that Ivan did this had incentives to lie. I told you that they would bring in well, I thought there'd be more than one witness, but I told you they would bring in witnesses that would say Ivan did it, and that I could show you by the evidence that those witnesses had strong incentives to tell the story the way that the indictment, which is not evidence, in this case, claims things happened. Right? I told you that people got deals in order to testify. I told you that Anderson got to plead to a probationable offense for coming in here and saying what he said. And he told you that he was pretty sure he wouldn't be able to do that if he didn't say what he said, right? The other one, he refused to testify. You know, I mean, that happens. Anderson, when I asked him on cross-examination, if you guys remember, I was like, so only after you realize you're getting charged with murder do you ever even tell anybody that Ivan's involved? And then you thought, Mr. Anderson, that if you put it on Ivan, they wouldn't charge you with murder. Do you remember me asking that? I hope so. There's been a lot of stuff talked about. I hope that you guys kept paying attention. I think you did. And even though he thought he wouldn't, get arrested if he said it was Ivan, they arrested him anyway. Oh, man. And then he was facing the same charges and facing potentially life in prison. Now, I just want to say this really quick because the state says, well, a couple things that I have to address. One of the things they said was that you don't have to determine the guilt of a person who's not sitting here in this case, and you don't. right? We know, and even if you did, I mean, he's not here. He's not here to defend himself. But Anderson has admitted his part from the beginning, right? Not to the police. He had to warm up to that. He had to change his lies slowly with them to get to the point where he blamed it on Ivan, right? But when I asked him why he's now testifying the way he is, he says that he had a change of heart and he just feels bad. He wants to take responsibility, right? You know, don't have to prove his guilt because he admits his guilt. But when we're talking about the possible sentencing for the crimes that he was allowed to plead out of, it's entirely relevant to your decision. It's completely relevant to your decision. Because it's up to you guys to judge the credibility of the witnesses they bring in here. And you can't do that if you don't have a full understanding of what they're getting by doing what they're doing. As he said, some people would say anything to prevent life in prison. And he said that twice. That he did it back then when he thought it would get him away from getting charged, and that he would do it now. It's entirely relevant. Whatever. The judge has instructed you, and you're going to have the instructions. But there are some things I just need to point out because they're being said. I told you that they told you, and they did. I told you that they were going to show a bunch of text messages that they were showing you guys and try to tell you that that's evidence of criminal activity. But the judge has instructed you, and it's in your instructions, that that type of evidence is not evidence in itself. All of these conversations that they've tried to piece together through text messages that they've gotten over a long period of time are presented to you guys so that they could pull out certain ones and tell you, see, this is probably, it's consistent with people talking about getting rid of a gun. It's consistent with people worrying about getting arrested for something. But the judge told you, and it came out on Friday during questioning, that anyone who tells you what those messages mean is speculating. I told you this at the beginning as well. If you're going to be asked to consider whether a statement is true or false, you have to be able to talk to the person who made it. And we didn't get that here. Unfortunately, Dre was one of the people. And I told you that I was going to show, why the context that these were put in is different. So that's one of the promises I wasn't able to keep. But the judge has instructed you, will instruct you. It's in your instructions. The witness said, with a laugh, actually, that everything she was asked about the meaning of those text messages was speculation. You don't get to take someone else's interpretation of words and consider it truth. So the instruction, which I understand, I'm going to spend just a minute on because it's a little bit complicated, I think. But the instruction is that the text messages were introduced to you not because they're evidence, because they're not. Any text messages sent by anyone except for Ivan.
That's a mischaracterization of the law.
All right, well, I'll read the instruction. I was going to get to that later, but...
Any arguments, obviously, on what the law are, I need you guys to refer back to the instructions, and Mr.
Right.
Scroggins is going to read the instruction, which contains the proper statement of the law.
So I'm just going to in my old-fashioned way. Is this on?
Now it is.
Okay. I apologize. Can I move it so I can stand here? All right.
As long as we don't unplug it.
All right. I don't know that this is any better. I don't think it is. All right. Can everyone see that? Do I need to?
You can zoom in or make it less bright.
All right. Auto tune, is that gonna help?
No.
No?
Zoom or right.
Oh my. Zoom, okay, all right, I found it.
Found it?
Doesn't seem to be, okay, there we go.
Try the brightness.
The lamp or, oh, the brightness, turn it down or up?
Down.
Is that- Okay. Okay, thank you so much, and again, I apologize, but you're gonna have this with you, the judge has already told it to you, but just because it came up, I'm gonna read it to you and you'll have it. It says, "In the course of this trial, you have been provided with text messages between the defendant and other individuals. You are instructed that the content of the text messages from individuals other than the defendant are not evidence, and you may not consider them for the truth or falsehood of the matter asserted in the statement. The sole purpose of these text messages is to show the effect, if any, that the statement had upon the defendant, and for no other purpose." That is the law. And I think I did tell you in opening statements that you were going to see a bunch of text messages that they were going to tell you were consistent with their theory of what happened. And having read what the law actually is, I think I kept my promise. Those text messages don't prove anything. They've told you what they think they mean. They had someone speculate about what they thought they meant. But the text messages themselves are not evidence. Now, that's a very, I know it's a confusing thing to try to keep straight. What does that mean? I can't consider the truth of the statement made by the other person except how it affects the listener, right? So the classic examples are things like, if you read a statement from someone, a text message that says, "The house is on fire," if that came in by itself in a case like this, the way these messages came in, you couldn't consider whether a house was really on fire or not. It doesn't matter if it's true or not because it's not evidence. What does it mean to see how it affects the listener or the reader? If someone sends a text message and says, "Get out of the house, it's on fire," and that person says, "Oh my God, I don't want to burn," and they leave, right? Then that's evidence that the person reacted to that statement, right? But the house didn't have to be on fire for the person to react to it being on fire. It could be a lie. I hope that helps clarify that instruction. That is one of the hardest things that we have to keep straight. But what it means is kind of like what I was asking Friday, like some of these statements where the state keeps saying, well, that's like if someone was doing this. That's like if someone was doing that, right? Well, it's like if someone was doing other things as well. You're not allowed to look at those messages, especially when it doesn't clearly say anything, because it has to be interpreted. And even if it were in plain English, you couldn't consider it for its truth. When I asked, I said, okay, where it's talking about, hey, we've got to get you moved, and there was kind of laughter because she said that would be speculating, and then she admitted, like, everything she said about those messages was speculating. I think that shows you guys what I'm talking about, right? The state takes a statement like, we've got to get you moved, right? And not even looking at the truth of it, the fact that Ivan says, yeah, this is a statement, by the way, that's made a month after this incident. The state tells you that, of course, means that he has to move because he's guilty of a crime. And I asked, I said, well, couldn't it mean also that he's moving to a new apartment? And they said that was speculation, and it was. And it was. So just remember that when you're going through that evidence. If any one of you tries to say that any one of those statements that was made by someone to Ivan is evidence, they're just not following the law. They're just not following the law. And so when you're reviewing those things, I want you to keep that in mind. I know a lot of you have kept notes and stuff, and I think you guys have been a great jury in the sense of paying attention to what's been going on in here. Have that little exercise. Look at all the stuff that was given to you, not just what was shown to you by the state in here, and just get it out of your head what they told you it meant, and just read it. Just read it. And when you do, follow the law. Remember, the message from the person isn't evidence. It's only evidence if it proves that the defendant's reaction to it indicates he believes something. Look at them like that. And remember, again, the burden of proof here. I don't have to prove what anything meant. And I couldn't with that evidence. One more thing, consistent with a person who is guilty. You don't get to convict on that. You just don't. Let's see. Okay. I promised you that the evidence that they did produce, if you take it at their word for him trying to sell a gun, will also show that he was trying to sell the same gun before this incident occurred, right? But they don't think that that means anything. It only matters that he was trying to sell it afterwards. And remember, he's not on trial for trying to sell a gun, guys. So if it doesn't mean anything before, how is it so meaningful after? You have to ask yourself that. Because selling it after is consistent with the guilty person, which is what the state wants you to look at. Having already been trying to sell it all along is consistent with a guy who's been trying to sell a gun for a while. But that's not consistent with guilt. And I also promised you that Garrett Ogata would be at this trial, and I thought I might not keep that promise, but he did show up, right, guys? Sorry. I kept my promises, guys. I kept my promises. The evidence showed what I told you it was going to show you. Now, I've covered a lot of ground. And let's see. Now, I would like to discuss the evidence. Your Honor, if we're going to take a break, would it be possible to do that now? Because I have a lot more I need to cover.
Ladies and gentlemen of the jury, do you need a break? Yes? Okay. We'll take a 10-minute break. During the recess, you're admonished not to talk or converse about the trial amongst yourselves or with anyone else on any subject connected to the trial, or read, watch, or listen to any report of or commentary on the trial of any person connected with this case by any medium of information, including without limitation, newspaper, television, internet, and radio, or formal express any opinion connected with the trial until you're back together in this room at 2:25. All right. Stand for the jury. All right, the jury has exited the room. We'll be in recess.
Thank you, Judge.